friends, welcome back to my channel. If you are new viewer, please subscribe my channel for more videos. आज हम बात कर रहे हैं सुप्रीम कोर्ट के जजमेंट की, जो कि है सूट फॉर पोजेशन ऑफ ए प्रॉपर्टी कैन बी डिसमिस्ड ऑन द ग्राउंड ऑफ लैक ऑफ इट्स आइडेंटिफिएबिलिटी। ये कहा है सुप्रीम कोर्ट ने। द सुप्रीम कोर्ट और वेडनेसडे states that a suit for possession of a property can be dismissed on the ground of lack of its identifiability. The bench of Justice Vikram Nath and Rajesh Vindal, while dealing with the appeal challenging the judgment and order passed by the Madhuri bench of Madras High Court, whereby the second appeal filed by the defendant respondent was allowed. In this case, the appellant instituted a civil suit for declaration of title, possession or permanent injunction against the respondents of the Court of District Munsif cum Judicial Magistrate at Aurelian. Earlier in 1976, the respondent had filed a suit for adjustment of the appellate. The said suit was dismissed. First appeal and the second appeal were dismissed by the High Court. The appellate continued in possession of the property in suit. However, the respondent were trying to interfere with the possession of the appellant. The trial court decided the suit for declaration of title, possession and permanent injunction would only with respect to the portion over which the house property was instituted out of the total extent of 8 cents of the suit property. With respect to the other property, the suit was dismissed. Aggrieved by the dismissal of the suit, the appellate preferred an appeal. The sub-judge declared that the appellant was entitled to the entire suit property for relief of declaration of title, permanent injunction and for setting up their boundary for securing the said property. The sub-judge had mainly relied upon the judgment of the High Court dated 30/3/1990 in the earlier round of litigation. Aggrieved by the judgment of the sub-judge, the respondent preferred a second appeal before the High Court. The High Court allowed the appeal, set aside the judgment of the sub-judge and restored the decree of the trial court. Counsel for the appellant submitted that under the law of merger, the judgment of the trial court and the first appeal court in the first round of litigation married with the judgment of the High Court dated 30/3/1990, and it is that judgment along which has to be read as final and binding between the parties. Supreme Court stated that the doctrine of the merger is a common law doctrine that is rooted in the idea of maintenance of the decorum of hierarchy of court and tribunals. The doctrine is based on the simple reasoning that there cannot be at the same time more than one operative order governing the same subject matter. The bench looked into the case of State of Punjab and another versus Devens Modern Various Limited and others, where it was stated that judicial discipline envisage that a coordinate bench follow the decision of an earlier coordinate bench. If a coordinate bench does not agree with the principle of law enacted by another bench, the matter may be referred only to a large bench. Supreme Court appoints that following the principle of judicial discipline, lower or subordinate court do not have the authority to contradict the decision of higher court. The trial court and the high court in the second round of the litigation violated this judicial discipline while adopting their position contrary to a high court's final judgment date 30 March 1990 from the first round of litigation. The bench observed that the trial court, as also the first appellate court, had not recorded the actual boundary or the measurements of the property in possession of the mother of the appellant. The respondent had based her case on the ground that they had purchased 8 cents upon piece of land, open piece of land, and the appellant had right construction over some adjoining land and had trespassed over part of her purchased land. As such degree of possession be granted. Supreme Court opinion that a suit for possession has to describe the property in question with accuracy and all detail of measurement and boundaries. This was completely lacking. A suit for possession with respect to such a property would be liable to be dismissed on the ground of its identifiability. If the construction by the defendant were not made over 8 cents of purchased land, then the plaintiff would not have a claim to possession of the same. In view of the above, the bench allowed the appeal. केस टाइटल जो है मेरे पुरुषोत्तम एंड तेलवी कंज्यूमरी एंड अदर्स। बेंच है जस्टिस विक्रम नाथ एंड राजेश बिंदल की। केस नंबर है सिविल अपील नंबर 9941 ऑफ 2016। तो फ्रेंड्स, अगर आपको मेरी ये वीडियो पसंद आई हो, इफ यू लाइक माय वीडियो, प्लीज लाइक, शेयर एंड सब्सक्राइब माय चैनल एंड गो टू माय द चैनल प्लेलिस्ट and more videos you found. So if you like my video, please like, share and subscribe my channel. Thank you for watching this video.